I am Prabha. I am a professor of law and social justice at King's College London, and I'm absolutely delighted to welcome all of you today to discuss two very critical bills relating to ARTs and surrogacy in India today. Both of them are pending before Parliament, and we have a distinguished group of doctors, medical ethicists, and a commissioning parent, and feminists and academics who will be discussing various aspects of the two bills today. So needless to say, ARTs have offered millions of couples and individuals around the world uh, an opportunity to form and complete their families. And at the same time, ARTs and practices such as surrogacy raise a whole range of ethical, moral, medical, legal, and social issues that need to be discussed in great depth, as well as regulated in detail, so that in fact all stakeholders and parties to the various transactions have clarity and certainty when it comes to these processes. Now, the Indian legal journey has been anything but that. So for the past 15 years, we've gone from being a fairly liberal jurisdiction when it came to access to ARTs and surrogacy to being a prohibitionist system, which is deeply exclusionary and which is also worryingly unlikely to be able to address the exploitation of women and children. And clarity and certainty have certainly become casualties along the way. So even lawyers in the room would be quite hard pressed to recollect every twist and turn when it comes to the laws on surrogacy and ARTs. So this is not a satisfactory scenario by any means, but it does appear that we might be witnessing the culmination of these regulatory initiatives. So just so that we're all on the same page, the Surrogacy Regulation Bill 2019 has been considered both by the Lok Sabha and the Rajya Sabha. It has been considered by a parliamentary standing committee as well as a select committee. And we are yet to see the final version of the Surrogacy Regulation Bill to see which of the suggestions of the select committee have been accepted. Now, one of the key recommendations of the select committee was that, in fact, the ART bill should be passed before the surrogacy regulation bill. And therefore, the ART bill 2020 was introduced in the Lok Sabha on September 14th of this year. And it has already been referred to a parliamentary standing committee, which is due to submit its report by January 3rd. And I'm hoping very much that our conversations today will feed into this deliberative process. And with this hope, I would now like to introduce our various speakers today. I will introduce them in their speaking order. So first we have Dr. Sneha Banerjee, who is an assistant professor at the Department of Political Science at the University of Hyderabad. Her doctoral research at JNU was on commercial surrogacy in India. Then we have Dr. Naina Patel, who needs no introduction. She put Indian surrogacy on the global map and is the founder of the Akanksha Fertility Clinic based in Anand, Gujarat. Then we have Dr. Shivani Sachdevgor, who is the founder and director of SCI Healthcare Services. She's practiced as an obstetrician and gynecologist and infertility specialist for several years now. And she completed her studies in Bombay in 2000 and then was an IVF clinical fellow at Hammersmith Hospital in the UK. We then have Mr. Sameer Kukreja, who is an entrepreneur in the IT security sector and who, with his wife and the help of a surrogate, is now a parent to two twin children. We then have Dr. Mala Ramanathan, who is professor at the Achyuta Menon Center for Health Science Studies in Thiruvananthapuram, where she teaches research ethics and public health ethics. And she's also an editor at the Indian Journal of Medical Ethics, which is published by the Forum for Medical Ethics in Mumbai. And last but not the least, we have my colleague, Dr. Bronwyn Parry, who is a professor in social science, health, and medicine. And she's also the head of the School of Global Affairs here at King's College London. And she was principal investigator for a large research project on the production, consumption, and regulation of ARTs in rural and urban areas within India. And although we do not have a surrogate in our midst, the omission is not deliberate. And we very much hope that academics and doctors will channel the experiences of surrogates into our conversation today. So, very warm welcome to all of our speakers and all our attendees as well. The plan is as follows. We will each speak for about 10 to 12 minutes, and then we will open up for Q&A. Please do feel free to type in your questions into the chat function in Teams. It is not as user-friendly as Zoom, admittedly, but please do not wait until the very end. In case you need to go, I will make sure that your questions are addressed by the panelists. And also, please mute your mics and videos during this session so that, because we're taping this session to make it available later on. So we will now start with Dr. Banerjee.
Thank you, Professor Koteswaran, and thank you, and good afternoon or good morning, depending on your locations. I'm going to, in the interest of time, not really present an exhaustive summary or a laundry list of the various points on which the surrogacy bill can be subjected to criticism or a critical engagement. But what I will try to do is to present a snapshot of its salient features and also some points on which Professor Koteswaran and I have critically engaged with it, and I draw some of these points from a forthcoming article that is going to come out very soon in the Indian Law Review. As Professor Koteswaran at the outset highlighted that two parliamentary committees have already examined the bill. There have been several versions. But what is noteworthy is that the current stage at which it stands is that it is pending in the Rajya Sabha, and the Rajya Sabha Select Committee, which looked at the bill, has presented some recommendations which are reported to have been accepted, but we still don't know exactly which ones. So what are the salient features of this bill? Attempts at regulating surrogacy broadly nestled under the umbrella of assisted reproductive technologies can be traced as far back to 2002, when the Indian Council for Medical Research first drafted guidelines that were finalized in 2005 as the national guidelines for the accreditation, supervision and regulation of ART clinics in India. And that included surrogacy, which then gave way to the ART bill, which Professor Koteswaran will talk about in detail. What is most noteworthy is that the surrogacy bill represents the first instance of separating the process from the umbrella of ARTs for the purposes of regulation. In separating surrogacy from ARTs, the bill does not fully address the complexities in the process, given that the type of surrogacy undertaken is gestational, it is medically induced, following in vitro fertilization, and may also include the use of donor gametes. Therefore, rightly so, the Parliamentary Standing Committee, as well as researchers and voices from the civil society, have argued that the surrogacy and ART bills be brought in together. In breaking away from the draft ART bills, the surrogacy bill also brings in a discriminatory approach with introduction of restrictive eligibility criteria for those who can access or who can be surrogates. It limits commissioning or intending parents to be heterosexual married couples who have been married for 5 years and are certified to be infertile. And all of these are actually, one can unpack these categories, and clearly they exclude people who do not fall under these. The women who can act as surrogates are supposed to be close relatives of these couples. By bringing the process thereby within marriage and family, though not defining who is a close relative, it also prohibits any payments to the woman acting as a surrogate, and hence it bans commercial surrogacy. But noteworthy here is that it allows for altruistic surrogacy and it doesn't ban surrogacy per se. Um, and in such an altruistic arrangement, commissioning parents are envisioned as bearing all the costs and also providing for an insurance cover. Again, the modalities of which aren't clarified in the bill, and it disallows clearly any form of remuneration or even compensation. The Parliamentary Standing Committee had in fact recommended a compensated surrogacy model beyond the commercial versus altruistic varieties to factor in, and this is important, it enlisted a rationalization of such a recommendation that it should factor in the time dedicated to this pregnancy, the loss of wages, the cost of health, and even, interestingly, the non provisioning of reproductive labor for her own family during the pregnancy as a surrogate. The Rajya Sabha Select Committee doesn't echo this, neither did the version that was introduced in Rajya Sabha factor this in. The Rajya Sabha Select Committee, in fact, recommended that it broadened that not just close relatives, but any willing woman can act as a surrogate, but still she cannot be compensated. And to quote, it said that it sort of recognized the latent in performing motherhood and reproductive labor, which uh, not just cannot but should not be compensated. Apart from banning commercial surrogacy, this bill also formalizes the ban on foreigners commissioning a surrogacy in India. Restrictive criteria were already being brought in 2012 onwards through various executive orders by the Ministry of Home Affairs, by first introducing the requirement of special visa, and not surprisingly also that they be married couples, in addition to a few more criteria. Interestingly, the prohibitionist approach taken in the surrogacy bill echoes some of the recommendations of a 2009 Law Commission report, which had taken suo motu cognizance of the issue soon after the first version of the draft ART bill was announced in 2008. There are numerous aspects, as I said, in this bill that can be criticized, but I'll just limit myself to a few. Um, while the ethics of surrogacy and a broader reflection on the process as a mode of reproduction might be subjected to a debate, it is definitely unacceptable to allow it for some while excluding others. The Indian state's regulatory approach towards surrogacy, patriarchal regimentation of possibilities opened by technology. While ARTs and surrogacy make it possible to make alternate families, the state attempts to conserve the heteronormative family and a certain understanding of purity of bloodlines. The question of a monetary remuneration or compensation to the woman who acts as a surrogate or even an egg donor is also an important one. While recognizing the merits of compensation, Professor Kotiswaran and I have also emphasized that not compensating for providing reproductive labor can be tantamount to violation of the Article 23 of the Constitution of India that prohibits forced labor. There is judicial precedence, particularly in accounting for women's reproductive labor, while determining compensation under the Motor Vehicles Act and insurance related matters, and childbearing and providing bodily material like oocyte or eggs are reproductive labor too in this sense. And this is not the only aspect that can be argued to be in violation of constitutional provisions. In the light of recent judgments like Navtej Johar and Puttaswamy, there can be constitutional challenges to the discriminatory approach of excluding cohabiting couples, single individuals, and same sex couples, violating their right to privacy and reproductive autonomy. Lastly, it is very important to probe how the elimination of compensation for women who act as surrogates is going to ensure the protection of these women from exploitation, one of which is a stated objective of this bill. Even as the Rajya Sabha Select Committee recommends opening up for overseas citizens of India and persons of Indian origin, women are supposed to be bearers of, and I quote from the Rajya Sabha Select Committee, divine warmth and affection, and be role models as surrogates for those in need. But who would such willing women be, and how would the government prevent their forced labor and exploitation? Especially if it is to be arranged within families, There is no dearth of evidence how exploitative, discriminatory, and violent families can be. And that's it for now, and we can come back during discussion.
Wonderful. Thank you so much, Sneha, for that really excellent presentation. So what I will now do is say a little bit about the ART bill. So as we know, the ART sector is much larger than the surrogacy sector. And, it is said that, about 27 million infertile Indian couples seek ART. And so, the critique that I have of the ART bill um, follows along the line of critique we have of the surrogacy bill. So it's quite exclusionary. It only allows ART for a married heterosexual couple and a woman above the age of marriage. So it excludes single men, cohabiting heterosexual couples, and LGBTQI individuals and couples from accessing ARTs. So clearly, this is, goes against the very spirit of the Constitution. And I just want to highlight the fact that in several other countries like, Israel and South Africa, which have robust constitutional systems like ours, bills of this sort, which are exclusionary, have been, tied up in litigation before the courts. So it would be wise for the Indian government to heed some of the radical sort of pronouncements of the Supreme Court in the cases that Sneha already mentioned. Also, the difference here is that under the ART bill, there is no prohibition on foreign citizens accessing ARTs. So it's quite ironic that foreigners can access ART, but not Indian citizens who are in loving relationships. So this is quite an illogical result. So this is something we need to bear in mind. Additionally, the ART bill does not protect the interests of the egg donor adequately. So the harvesting of eggs is an invasive process, and we know that if it's performed incorrectly, it can actually result in death. So the bill requires an egg donor's written consent, but does not provide for her counseling or her ability to withdraw her consent before or during the procedure, unlike for commissioning parties. She receives no compensation or reimbursement of expenses for loss of salary, time, and effort. Also, failing to pay for bodily services, again, we believe is unfree labor and it's against the Constitution. The ART bill only requires the commissioning parents to obtain an insurance policy in the egg donor's name for medical complications or death. But again, there is no amount or duration specified. So the bill also restricts egg donation to a married woman with a child who's at least 3 years old. And here again, I think egg donation as an altruistic act is possible only once a woman has fulfilled her duties towards the marital economy. Now, children born from ART do not have the right to know their parentage. This is also true under the SRB or the Surrogacy Regulation Bill. But this right was protected under previous drafts of the ART bill. Also, the current ART bill requires pre-implantation genetic testing, and where the embryo suffers from pre-existing heritable, life-threatening, or genetic diseases, it can be donated for research with the consent of the commissioning parties. Now, these disorders need specification, or the bill risks, allowing a program of eugenics. And prior versions of the bill also had provisions on regulating research using embryos, which this ART bill shies away from. And the most disappointing aspect of the ART bill is the fact that it is not synchronized with the surrogacy regulation bill. So actually, there is considerable overlap between the sectors, and the bills need to work in tandem, but we find that several ART processes are left undefined in the ART bill. So many of these are defined in the surrogacy regulation bill, but not in this bill. So clearly definitions of the couple, infertility, ART clinics and banks, all of that needs to be aligned. Also, a single woman cannot commission surrogacy but can access ART. Now, it's possible that the government is actually now heeding the advice of the Rajya Sabha Select Committee to say that single women can also, or rather divorced and widowed women can access surrogacy. And maybe once we see the new version of the surrogacy bill, the two won't be that contradictory, but as of now, they contradict each other. Also, the ART bill designates surrogacy boards under the Surrogacy Regulation Board to also operate under the ART bill. And this was again a recommendation of the Rajya Sabha Select Committee, which the government has heeded, and it's a positive move. However, both bills set up multiple bodies for registration, which will result in duplication or worse, lack of regulation. Also, worryingly, the same offending behaviors under both bills are punished differently. And the punishments under the surrogacy bill are higher. Also, offenses under the ART bill are bailable, but not under the surrogacy regulation bill. Also, records have to be maintained for 10 years under the ART bill, but 25 years under the surrogacy regulation bill. So we can find that the same actions which could be performed by a surrogacy clinic, which is also likely to be an ART clinic, are treated differently under the law. And it's clear that there is a certain imagination in the surrogacy bill of surrogacy being a deeply exploitative practice, which is conducted by fly-by-night operators. So this is the kind of presumption I think that the bill has, which explains the government would say the higher punishments under the surrogacy bill rather than, but not under the ART bill. Also, there are some issues that go to the very political economy of the two sectors. So prior versions of the ART bill required independence between the ART clinic and the bank, but there is no such distinction now. And gamete donation is not compensated anymore. So the question is, how will ART banks, in fact, be economically viable? Perhaps clinics will be allowed to operate banks as well and subsidize them through their ART services. Also, in previous drafts, gametes could not be gifted between known friends and relatives, but we don't know if this has changed now, if the bill is shifting to an altruistic model. Either way, it appears that gamete shortage is likely. And further, the bill's prohibition on the sale, transfer, or use of gametes and embryos is quite poorly worded. So it is bound to cause confusion for those relying on donated gametes. Um, Finally, there are some issues around, the bodies that are set up under the two bills. So the ART bill requires clinics and banks to maintain a grievance cell, but there is no detail on, exactly how the cell will work. Instead, I believe that clinics should have ethics committees, and also that mandated counseling services should be independent of the clinic. Also, we find that both the ART bill and the surrogacy bill have high sentencing provisions and very hefty fines. So now we know that the poor enforcement of the PCPNDT Act demonstrates that enhanced punishments do not secure compliance. If anything, lawyers and judges lack medical expertise. So this is again, quite difficult to in fact enforce. And also, there's an unusual provision in the ART bill that requires that all bodies set up under the bill be bound by directions of the central and state government in the national interest, quote unquote, friendly relations with foreign states and public decency and morality. Now, it's quite odd. To begin with, one would expect bodies to be subject to, any mandates from the governments. Um, but it's possible that the government is worried that, in a prior phase of surrogacy, medical establishments would often be more liberal in the way they treated certain medical processes. And it's possible that they don't want that to happen with the body set up under the ART bill. Nonetheless, I think at the very least it undermines the independence of these bodies, and it's also a bit suspect because the grounds are rather broad and vague. So I'll conclude by simply saying that it is a welcome move that the ART bill has been referred to the standing committee for discussion. But at the very outset, there seems to be a lot to discuss, and a lot of drawbacks. And I'll stop there and then hand over to Dr. Patel.
Prabha, can I have a slide share?
Yes, please go ahead.
Yep, I'm trying to do that. Can you see the slides?
Yes.
Okay, so I think I will start the session now. First of all, greetings from Akanksha Hospital Research Institute, and good day to everybody who is there. I thank Dr. Prabha for arranging this webinar, which is the need of the hour. And definitely we should be visiting the ART and the surrogacy bills in India. We know that infertility is on rise, and worldwide the assisted reproductive technologies are used in a big way, and this is still expected to grow bigger and bigger, including in India. 1 in 6, and now they say 1 in 5 couples will need the assisted reproductive technology to have a child of their own. And if we look at Indian market, this is 2018, 30 million couples are estimated to be infertile and will need such assistance. The main reason being the lifestyle factors, the delayed marriages, delaying in bearing a child, then the toxins, the environmental pollutions, which gives rise to low sperm count, low egg count. The females who are career oriented would want to delay childbearing, and the other infectious diseases, etc. If we look at surrogacy, yes, it will remain, the demand will remain forever. If you look at the first indication, 1 in 4,000 girls are being born without uterus. Uterus transplant is not that successful. I would not say anywhere near surrogacy. And there are a lot of females who have uterine problems like fibroids, adenomyosis, or they may be bearing a child. There will be a difficult labor. The baby will deliver and it's a dead baby stillbirth, and there is a lot of bleeding and doctor has to remove the uterus. So imagine a female going through that emotional turmoil where she was just waiting to hold a baby in the hand, does not have a child now and is already hysterectomized, cannot carry a child. So a lot of these indications are there where people will need ART and surrogacy more and more. If we look at IVF, we use the own egg and sperm, but there is need for donor egg, donor sperm, and sometimes even donor embryo, what we call preconceptional adoption and surrogacy. So I'll first start reviewing the ART bill. They have mentioned the commissioning couple, and which you already said that they have left out the live-in couples. The Indian court has recognized live-in couples. Alimony is being given to the live-in couples when they separate. Then why not allow them? More and more couples in India also are choosing not to marry but have a baby together and stay together. So it is unethical, shocking, and unfair to deprive them of their just right. Then we look at the age of the commissioning couples. They have said that the men can go up to 55 years, but a female up to the age of 50. Why can't we increase this to 55? Because we know now that 50 is the new 30 and 60 is the new 40. And I'm not talking about the urban area. The couple who you see here has a baby at the age of 51 when the female is 51. So they also have had infertility for 30, 35 years, 40 years, and now they have a hope. They are aware that with IVF and a donor egg, they'll be able to have a child of their own, or the female feels she can carry a child of her own. Then why not? Why do we restrict at 50? Because in 40 plus, there are females who are getting married, who are absolutely healthy and fit. So if they are medically fit, at 55 also they should be allowed to carry their own child, because this is what we experience from our practice, and we know how many such females approach us for infertility treatment. The biggest point over here now is the oocyte donor. They will mention that she should be an ever married woman having at least one live child of her own, which is also minimum of 3 years of age. She can donate only once in her life and not more than 7 oocytes. All these points are problematic. First of all, why ever married women? If we see all over the world, even there are university students who want to pay off their fees would go and donate eggs because they get a proper reimbursement. So married, a female of 21 years can vote in India. A female of 18 years is allowed to get married in India. But if she has to donate egg, she has to be married. Why? That is one thing. Second, why she should have a child of her own. She doesn't want to conceive, but she wants to donate and see her baby. Okay, I want to donate, but I don't want to conceive. Why force her that you should have a child before you donate? You are depriving again the autonomy of the female, the right that she needs to choose. And I know the articles in the constitutions are here again. You are contradicting them. Once in a lifetime, I will come to that with the ASRM study where they allowed American Society of Reproductive Medicine at least 6 times, because already there is a huge shortage of egg donors, and then restricting it to one will make it even further worsen the procedure. Then you are saying 7 oocytes. Medically, it is not possible. You select an egg donor who has a good cohort of 10, 15 eggs. And when you start stimulating even with the lowest possible dosage, whatever is the basal antral count will start growing. So supposing the donor has showing 15 eggs or 14 eggs, and ideally, a 15 egg number is ideal to get one healthy live baby. So if we are looking at this and we are just retrieving 7 and leaving the other eggs, it will be harmful to the donor. And if you are giving 7 eggs to the recipients, her results are also not that great. So this particular thing, I think they need to consult the doctors who are practicing this, take the practical opinion and come down that it is not the legal body or the bureaucracy who decides how the medical procedure will be done and how it will be, what is the proper medical technology to be used for the egg donor. So these points are really, according to the medical fraternity, at least 4 times and with a gap of at least 3 months should be allowed. So I'm coming back to this ASRM opinion, the American Society for Reproductive Medicine, where they have recommended at least 6 cycles for the donor. And the reason behind this, they have done the long-term risk studies and they have documented that there is no long-term risk associated with oocyte donation. So as of now, it may be reasonable and prudent to limit the number of stimulated cycles to give oocyte for not more than 6. So restricting to 1 is medically, in our opinion, not correct. Now we look at the storage of the gametes. This is another problematic area. Previously it was 5 and in the new bill they have said 10. But why limit to then when we know the gametes and embryo can be good even after 15 years? I would say that there is a boy who has come for cryopreservation of his sperm because he is undergoing a chemotherapy. And in 10 years, I am sure he doesn't want a child of his own. So what to do? So they have to look at this from the practical point of view. Similarly, females, now there is an option of preserving the ovarian tissue if she has a cancer and as she undergo any treatment for that. So these storing of gametes can be extended to 15-20 years, or there should be some provision for such patients. Offences and penalties. This is the most problematic area, which is a fine not less than 5 lakhs or up to 10 lakhs and imprisonment for 8 years. In which country gives this type of punishment? The doctors are not hardcore criminals. Any profession, you can do a mistake knowingly or unknowingly. But the doctor is definitely working in the best professional capacity. Then why such a big action of 25 lakhs? Why such a bias against the doctors? Then they have not prescribed which type of irregularity. Even minor irregularity or somebody can frame you. Such draconian laws, I don't think is acceptable, and the medical profession will suffer the brunt of unreasonableness. Now the sex selection part, definitely it is not allowed in India, and already the ART clinics have to submit. If we do PGS, pre-implantation genetic screening or diagnosis, we have to submit the forms to the PCP and DT. So again it is duplicating the full thing, and we have to have again submit those to another board, and that is a problematic area. Import and export of embryos. It was totally banned in an overnight notification from the Home Ministry that now it will be criminal if you import or export embryos. Supposing our patient who lives in US and had so many of such cases where she has a breast cancer and she has to undergo chemo and she has frozen her embryos there. Now she cannot carry a child and she wants this to be done by a surrogate, even a sister in India, but those embryos cannot come. There are foreigners and NRIs whose embryos are here, and now that surrogacy is banned for foreigners, we need to export them to their country. And it has been a horrendous time for all of them for all these years. 278 foreigners and NRIs embryos I have in my clinic, out of which successfully I have been able to send it back to just 5 after a long drawn procedure and getting an NOC last 1 year only. So this should be allowed. Proper guidelines should be kept, but we cannot deprive a couple of their embryos, either importing or exporting. Lately, on June 12, 2020, we have found that export will be allowed, and even they mentioned the import could be allowed, but we all know that it's going to be a long drawn procedure rather than making it a simplified one. In ART bill, it was never put up on the website to get the views of the stakeholders. We were waiting for it. I don't know whether the suggestions, consultations were taken, but any bill that is coming up in the parliament is, as a rule, put up on the website for all the comments by the stakeholders, which was not done. And ideally, an ART bill should come before surrogacy bill because we cannot do surrogacy without ART. So that is a very logical thing to do, to bring the ART bill and then surrogacy or combine the two. Because in India, all the ART centers are doing surrogacy. They are not designated few surrogacy centers. Anybody who does ART will be doing surrogacy. So combining the two bills is the most prudent way to go ahead. Now this is the story of surrogacy bill. The first Indian couple who lives in the UK, this girl, grandmother delivered the surrogate children. So, which is the intending couple, again of Indian origin, they will be legally married and then they should have a certificate saying that they need this surrogacy and only for altruistic purposes. There is no commercial purpose or commercialization, and the word compensated has not been used. So now that they have said that okay, and any lady willing to become a surrogate can do it, a near relative is not required, is a big step. But when you ban commercial, when you ban compensation, that means surrogacy is banned. I have seen even within the families when a sister or a sister-in-law is becoming a surrogate, they do not give cash, but some kind of help is given. Even to this grandmother case, I know help was given to the grandmother. So in this time, I don't see anybody doing it purely altruistically. Some kind of compensation is already given. And if these prescribed expenses are not mentioned and the surrogate is not compensated, I see that it is the end of surrogacy practice in India. Compensation should be allowed. Single woman, but if she has never married or is not a divorcee, she is not allowed. She has to be a widow or she has to be a divorcee. Why discriminate between two single women, one who chooses not to marry but have a child and one who is a widower? Then same-sex couples are not allowed. Live-in couples are not allowed. And again, foreigners. What is the harm in doing for foreigners who genuinely need? And when there was a set protocol of medical visa in 2012, well, everything was checked and then the baby was delivered and taken by the couple who were there. Married or unmarried should be treated similarly. We have seen children being adopted by unmarried people in India. For a male, it's only a girl, but otherwise they are allowed. So why not allow this also surrogacy for them? The other issue is this was an overnight. The notifications in India are terrible because overnight we were told that from tomorrow, 5th November, you will not be transferring any embryos of foreigners or OCI in the surrogate mother. And that is the reason that in just when the injections were going on, IVF was going on, or we had the frozen embryos waiting for the surrogate, it was stopped. The intending couple, the next criteria, should not had not any child biologically or through adoption or through surrogacy earlier. When you allow adoption for 3 children, previously it was 4, now 3, why stop at 1? There are people who definitely want 2 children, and in India there is no such law that you should stop at 1. So if naturally you can have 2, 3, why not through surrogacy? Through adoption you can have 2, 3, why not through surrogacy? And the worst part is that if you have a child which is mentally or physically challenged or suffers from life-threatening disorder, you can do it. So that means you are again trying to discriminate a normal child from a specially abled child, which is very, very wrong, I feel. And people should be allowed to do surrogacy and not stop after 1 child, maybe 2, 3 that they can frame it, but stopping at 1 is not correct. No woman then other than 25 to 35 years of age, there they were suggested 39 years, but we do not know. Egg donation will not be done by the same woman. That should be the criteria. Here they have written that shall be a surrogate mother or help in surrogacy by donating her egg or oocyte. Even now we do not take the eggs of the surrogate. It is an anonymous egg donor. But egg donation is a very important part of surrogacy. Equally, I would say sperm donation sometimes when they've tried a lot of cycle and it's a male factor that's not giving the good embryos. So what is important is when the couple wants a genetic link with the baby, one of them can have it, and that is a rule. But they don't jump onto surrogacy couples immediately. They themselves try. They go for IUI, IVF, laparoscopy, number of failed cycles, and that time when they come, already the female is 35, and we know the biological clock of the female is ticking. After the age of 32, her number falls of the eggs, and after the age of 35, they become abnormal. So by the time she decides I need surrogacy, she needs an egg donor too. So if egg donor is not allowed, compensation to egg donor is not allowed, compensation to surrogate is not allowed, I think that the surrogacy practice as well as the ART practice in India will have a black day that day. Now, in this time of pandemic, I'm sure Dr. Shivani must be having an all over India. Every day we get a mail or a call from all over India that I want to be a surrogate. I want to be an egg donor. I've lost my job. My husband has lost his job. So if I do surrogacy, at least this year of pandemic when we are jobless, we can take care of our family and our finances. And this is the reality. And these people, why should they not be allowed surrogacy compensated voluntarily if they want? And when there is a case of miscarriage, they have said that you have to take the written consent and you have to take the consent from the appropriate authority. Why leave that when there is a medical indication for termination of pregnancy? We have to wait. In an emergency, surrogate is bleeding, we cannot wait for the permission from the appropriate authority to abort the child. And finally, the number of embryos to be implanted. How can that be prescribed? It depends medically on the condition of the parents, the condition of the surrogate, and what number of children. Normally, it's one blastocyst that we transfer or 3-day 3 embryos that we transfer. So how can the bureaucrats decide how many embryos to be transferred in the surrogate and the number of boards? State board, central board, national board, whatever, and the number of people on these boards. It's a huge human resources and expense to the government, and for what? So that also should be diluted. And offenses and penalties, if you read this in the surrogacy bill, it is again very harsh and it is cognizable and non-bailable. So that means they can catch you first and then you have to prove your innocence, which is not the right way to go ahead. So that is the biggest part. If this clause is not removed, I don't think any clinic would want to do surrogacy in India. To conclude, I would say that infertility is on rise, but any bill that is being made, stakeholders should be there to give their comments and opinions. The commissioning couple and the people who can undergo ART should be, the terminology should be revisited. Embryo and gamete donation, once again, they have to relook. Penalties to the doctors must be revamped. It should be very, very diluted. ART rules again diluted. Surrogacy without compensation is like a ban. Gamete donation should be allowed in surrogacy. Offences, penalties must be refined. Major recommendations given to the surrogacy, to the select committee must be added. The select committee was in my center on 22nd January, about 80 people of them. And they really like the way the things are going on. So they had given their good suggestions, and whatever the bill is, you make it very soft rather than stringent. The more stringent you make, surely the demand is going to be there and the black market will start and the proper functioning will not be there. Thank you.
Thank you. Thank you very much, Dr. Phil. I now invite Dr. Shivani to make a presentation. Thank you. Dr. Shivani? Are you there? Dr. Shivani? Okay, maybe we can go on to Mr. Kukreja and then Dr. Shivani can speak right after him.
Yeah, I think she's trying to speak, but her mic is on mute. If you can ask her to unmute her mic.
Yeah, Dr. Shivani, could you please unmute yourself? I'm not able to do it from here. Can you please do it?
She's probably to give her a call or something.
Okay. So why don't you start, Mr.
Yeah. Well, I will do it. Yeah. Hi, everybody. A very good afternoon to all of you. Uh, I'm a very proud parent of twins, one boy and a girl, whom we had some 3.5 years back, courtesy an angel out here called Dr. Naina, who's sitting on the in a red sari. And they are fine, they are healthy, they are intelligent. Uh, they're pretty good looking. I might sound a little conceited out here. One thing, because you guys have gone into the detail of the legal aspects of the bill. See, one thing is a certainty out here. If this bill were to become an act, or if this bill was an act some 3 years back, and we could never have had children, or even not only us, even the Shah Rukh Khans, the Karan Johars, the Ekta Kapoors, the larger than life images couldn't have able to have children, right? I have a basic problem with the very opening statement of the bill. Where they try to classify surrogacy as both commercial and altruistic. The phrase altruistic surgery, I feel, is an oxymoron. Trust me, I'm this I am going through a personal experience. We belong to a very decent family backgrounds, right? So there were plenty of my wife's cousin sisters, real sisters in question, and all we received a flat no when we talked about somebody helping us by just giving their womb, because it's a long period. It's a 9 month. You cannot have an altruistic act for 9 months. Somebody is carrying your baby. She is going through regular pains, the food. Probably she's being deprived of a normal a man-woman relationship with her respective husband. We cannot expect this to be altruistic. Give me a break. I you know I really am in sync with Naina out here, Dr. Naina. Because this bill itself has been drafted by bureaucrats who absolutely have no idea of the process as per se. Let me read out this particular statement. Uh, Surrogacy is permitted when it is for intending couples who suffer from proven infertility. Surrogacy has nothing to do with male infertility. Surrogacy only takes place when the woman's uterus is not working. So poor man has no fault in this. He could be the most fertile person on earth. He still will need a surrogate. A. B, or in a case where the egg is also not there, the uterus is not there. So that is where surrogacy is required. So why should the man, the poor husband, go from pillar to post, proving his infertility or fertility? You have a check and balance there. You'll have some joker from some government department sitting there trying to question the woman and figuring out, अरे आप fertile नहीं हैं क्यों, लड़का आप fertile हैं क्यों नहीं, all that. So is virtually you're creating a system which will be almost impossible. Tell me how many couples, see Dr. Naina, and I'm sure the other couple of other doctors on board, Dr. Sneha and all, must be meeting couples who are fertile, infertile, both the couples are fertile, infertile. They want it a closed door interaction. They don't want to government offices who sit in the middle as regulatory bodies. Okay, pehle I'll give you a certificate of infertility to the woman, then tom-tom to the whole local area, and then that you're going to Dr. Naina, so that poor woman or the poor girl in this case is completely derobed in the society. So that's it for me as a person who went through the entire process. All these things are very important. I don't want the people in my close circle to know that my wife is infertile or I'm infertile, for that particular reason. Now coming to this, so this has to be clear. And one thing which I had a fight with somebody yesterday also, and I'm going to fight with Dr. Naina on this also. Why the hell are you comparing children born out of IVF to norms of adopting children? Why? So what is happening? What is happening? What is happening? You are taking your own sperm, you're taking your wife's egg and borrowing a womb. So how is that similar to adoption? It is similar to a natural process of giving birth to a baby. So if I am if I am going through natural process, I'm allowed. There's no one thing. There's no one child norm for a natural baby. There's no two child norm for a natural baby. So why are you stopping people from 1, 2, 3, 4? I'm sure Shah Rukh Khan went for a third child. We won't mind another fourth child by Shah Rukh Khan. So 3 Shah Rukh Khans for the next generation would be a very interesting proposition. So that is my second major objection area is. See, talking to Dr. Naina directly. So probably, ma'am, see, if the woman is infertile of nature 1, where the uterus is not working, the egg and the sperm belong to the couple, then it is a natural normal baby. Okay, fine. You can compare if even the egg is coming from a donor, the uterus is also a surrogate lady, and the sperm is just coming from the husband. In that case, probably it can be compared to adoption, but then it is tougher than adoption. I would like this particular aspect to be explained in the will, where before a man decides to go for this process, where he has to buy an egg, buy a womb, and create babies. So there are 2, 3 different scenarios which are created. A social scenario. Suddenly the girl she's got married to a guy who doesn't have kids. Suddenly 2 years, 3 years, 4 years down the line, now she has to bring up kids of absolutely a third party kids. So that is where I think the counseling for both the husband wife is necessary, or probably the checks and balances which happen in adoption are necessary, and so on and so forth. But so I feel there should be a clear classification of these two processes of surrogacy, right? Okay. Now second thing is that why wait for 5 years? I got married when I was 40, right? If I would waited for 5 years, I would have been 45. Science is so advanced today. You don't need 5 years to figure out whether your wife is infertile or you're infertile is some problem with fertility. I basically feel now fertility test should be mandatory even before marriage. So this this 5 year is a more scary phenomenon, because by that time, like this, you could be 50, your wife could be 50, you could be 55, and the state cannot pass a diktat saying that you cannot have babies. We are not staying in China, we are staying in India, right? So there's another point I wanted to and the third point which I want to talk about is that it will not be a black day for end of surrogacy. It will not be a black. It will be a black day for a lot of couples, lot of men who are not at fault. It will be end of life today at the age of 47 today. I cannot visualize my life in the absence of my twins. I'll have nothing to look forward to. I have plenty of money. Whom do I spend it on? You understand my point? What do I look forward to? What is the fault of that male who ends up in a marriage like this? A, B. What is the fault of a wife who ends up in a marriage where the husband is infertile? Why are that part of the couple deprived from having 1, 2, 3, 4, 5 children? Yeah? This is ridiculous. You cannot have stupid bureaucracy sitting in the middle over cups of coffee and tea and talking about all sheer nonsense. I was part of the Rajya Sabha committee, that committee you guys are talking about, where I spoke on behalf of you guys. You had people laughing around, you had people joking around, you had people pulling things out of their hat. And, there was a joint secretary there. She took off saying that a joint study by Oxford and Cambridge says kids born out of surrogates are not normal. So I told her, ma'am, stop faffing around. There's no joint study of Oxford and Cambridge. They do not see eye to eye. Oxford never works with Cambridge and Cambridge doesn't work with Oxford. So you're pulling a fast one. So that was the temperament. I had this strong feeling, that see, what I could feel as an outsider, as an entrepreneur was, this is a new science, a medical science where people believe it's a very money-making thing. So it has nothing to do with the altruistic nature or the surrogate nature. It is more a inter-field doctor jealousy. You have people who are running clinics of other nature who are making equal amount of money. They are jealous. Probably they didn't do gynecology or IVF studies at the right time. I would see the present government listens. And we should pull all our strings to reach out to the head of the state, because he listens. And if this bill were to be an act, to pull it back would be a virtually impossible situation. It is now. I request all the participants or all my fellow co-speakers, whomever they know, whatever they know, and however we have to reach out to the right people. And I'm going on here. If Dr. Harshvardhan doesn't see sense in this, let's go to some of the firebrand ministers we've got. We've got Smriti Irani, we've got a defense minister. We can write to the Prime Minister Forum directly. Naina Patel can use her Gujarati background to reach out to him, for all I care. She should put it on the Prime Minister's thing. Otherwise, if the bill becomes an act, it's not a joking matter. Forget money to surrogates. Nothing is free. Nothing is free. You talk about close relatives. Imagine in a family, we are actually, all of us are small families. One brother, one sister, one brother. You cannot request your side of the family, a man's side of the family, to bear a child. I can't tell my sister to bear my child. It's a very dirty feeling. It has to go to my wife's side of things. And what if she's the youngest child and all her elder siblings are older to her? Who wants to get into a controversy of getting into a cousin sister's scheme of things, and tomorrow getting made your life hell by your wife and the cousin sister also? So that is what my basic thing is.
Okay.
Rest Prabha can take over.
Wonderful. Thank you so much, Mr. Kukreja. Next, we have Dr. Shivani. I don't know if she's able to get on now. Dr. Shivani, are you there? Are you able to unmute yourself? Okay. Dr. Shivani, are you there? Okay, in that case, I think I'm going to invite Professor Braun to speak because I think she is also speaking specifically on the surrogacy bill. So we're going to alter the lineup slightly. So I now request Professor Braun Parry to speak.
Thanks very much, Prabha. Can you hear me and see me okay?
We can hear you, yes.
And see me?
Yes.
Okay, great. Thanks very much for this opportunity to comment on the Surrogacy Regulation Bill. I want to say something about the way in which I have come to the conclusions that I have about the Surrogacy Regulation Bill. With a team of other researchers, I undertook about 4 or 5 years of research in India on assisted reproduction and surrogacy in both urban and rural areas. So the things that I'm going to speak about now are based on our findings of that research. So we interviewed over 100 people and we spoke to many surrogates and intending parents during our research. So I would like that noted at the start. One of the things that I would like to say first of all about the Surrogacy Regulation Bill was mentioned earlier by Naina and some other commentators, which is the fact that the bill seems to be underwritten by a presumption of malign practices and intents. So there is discussion and mention of things in the bill like trafficking and prostitution and racketeering and so on. And I really want to take exception to that at the outset, because what I have established through my own research is that the people who are actually seeking to do surrogacy in real life are couples who are suffering from very real forms of structural infertility that are preventing them from having a child. They're not having a child because they want to put that child into prostitution or anything like that. I mean, I think those suggestions are frankly rather ludicrous. You certainly wouldn't go to the trouble and expense of producing a child via a surrogate for that reason. So these are genuine people who suffer from infertility, and they suffer from a particular kind of infertility. So they have a defective womb, for example, or they've had genital tuberculosis, or they have a Müllerian abnormality. So there are very clear reasons why they absolutely have to have a surrogate in order to conceive a genetically related child, and they can't do that in any other way. And one of the things I want to say about their experience actually is that, and this is going to sound harsh, but really no parents want to use a surrogate. They actually don't want to have to use a surrogate. What they want more than anything else is to be able to bear their own child themselves. But unfortunately, some of them at the end of the line reach a point where the only way they can have a genetically related child is to use a surrogate. And I think it's wrong that those people should be discriminated against just because they have a certain kind of infertility. So if, for example, your infertility is caused by the fact that your gametes are dysfunctional, so you have sperm that doesn't work or you have eggs that don't work, you can access assisted reproductive technology relatively easily. But if your infertility is caused by the fact that you have a defective womb, you are going to be put through a much more strenuous and difficult process in order to access assistance and be able to reproduce. And that seems to be inherently destructive to those people. Okay, so that's the first thing I wanted to say. The second thing I want to say is that the move to altruistic surrogacy is designed to prevent the exploitation of women surrogates. I understand that. And the idea is that if we move to altruistic surrogacy, then there won't be any exploitation. And I think that that is a false presumption, because it is absolutely clear that altruism does not guarantee non-exploitation. So just because somebody is doing something altruistically or being asked to do something altruistically does not mean that they won't be exploited. So as we know that there are many family members under this bill, close relatives, who will be asked by their desperate family members to perform this work of being a surrogate, and they will feel coerced to do that work, even if psychologically they really don't feel that it's something that they want to do. They will feel obliged and they will feel coerced to undertake that work, and that is exploitative of them. So I think we absolutely need to understand that. So there is a real possibility that some close family members who are women, whether they're sisters or sister-in-laws, will suffer real psychological damage and distress if they are pressed into becoming surrogates for family members when they really don't want to. And that is, I am sure, what will happen if we insist that only close family members can be surrogates. I have no doubt about that outcome. And what that leads me to, I guess, my next point is that being a surrogate is a very particular kind of labour or work. And not everybody, not every woman feels that they are able to be a surrogate for someone else. At the end of the surrogacy process, inevitably you have to give up your child to the intending parents, and many women don't feel that they are able to do that. However, some women do feel that they are able to do that. And if they feel they are able to do it for someone else, I believe that they should be allowed to do it. So for instance, here in the United Kingdom and in Canada, you also find some women, not all women, but some women who feel that they are able to do a surrogacy process for someone else. And we allow those women to do that in the United Kingdom, and they're allowed to do it in Canada as well. And they do not have to be related to the intending couple. So they are women who feel that they can do that work for someone else. So I believe that that should be possible in India too. It should be possible for some women who feel they're able to be a surrogate to act as a surrogate for other people, even if they're not related to them. And that brings us on to the question of compensation. I think it's absolutely clear that there is no distinct line between compensation and doing something in an altruistic fashion. So the bill says that you must have your medical expenses reimbursed and your insurance cover reimbursed to you. That should be arranged as a surrogate. But it does not allow for any other form of compensation. And I think that that is not the right way to go ahead. And certainly in the United Kingdom and in Canada, some compensation for surrogates is allowed. And the reason why it is allowed is because we believe that it is paternalistic to expect any woman to give up her labour, especially if she is taking time out of paid employment to do a surrogacy, whether that woman is a close relative or whether it is another woman who is unrelated to the family. It is quite wrong to expect a woman to spend 9 months of her life producing a surrogacy and not receive any kind of compensation for the time and the effort that she is investing in that process. So this brings us to the question about the fundamental question about whether it is wrong to offer compensation for women who are doing the labour of producing a child for someone else. And it has been suggested in the bill and elsewhere that producing a child is a very special kind of almost divine labour, and that it would be wrong for women to receive any kind of money or monetary compensation for that. But what I would say is that I do think that producing a child is a very special form of labour. It's a kind of, almost like a sacred kind of form of labour. However, I would argue there are other kinds of very intimate labour that people can provide for one another, and I'll give you 2 examples. So caring for very small children is something that we think that mothers typically do, and that is a sacred form of labour, nurturing a child. And equally looking after people at the very end of their life, revered parents who you love very much, is also a sacred form of labour. And yet we are happy enough for some people to do those forms of labour for others, as long as those people are appropriately regulated and overseen, and as long as they are doing it in the right spirit. So I believe it is actually possible to, and not morally wrong, to compensate some women for this particular kind of caring labour, nurturing labour, as we do for other kinds of labour. Now, the difficulty is by only allowing close relatives to become surrogates, and especially as my previous speakers have noted, in such a prescriptive way where people have to be this age and not have had a previous child, etc., etc. The requirements are so tight and so prescriptive that it is extremely likely that many people who actually deserve to have a surrogate, who have a form of structural infertility and need a surrogate, simply will not be able to find that surrogate within their own family. And so what are we saying then? Bad luck, you have the wrong kind of infertility, and you happen to come from a family that's all brothers, and so no genetically related child for you. Well, that seems very harsh and very discriminatory, and I cannot see any basis in law for coming to such a conclusion. So that is something that I feel very strongly about. There are a couple of other matters that I might just touch on before I conclude here. One is that the question around anonymity, and I feel I have to say something about this because in the bill it's presumed that the child does not have a right to know its parentage. I've been doing some research lately on genetic testing in the United States, for example. You'll probably be aware of ancestry DNA testing, where people try and discover, what their history is. And in the United States now, 26 million people have done ancestry testing, DNA testing. And I can give you an absolute assurance that these people are able to discover other people to whom they're related through this kind of DNA testing. And DNA testing is becoming very popular in India as well. And I have no doubt that even if we try and hide the parentage of these children, eventually those children will come to know who they're related to. So I think working on the basis of a presumption of transparency is probably not only the sensible but the only way to go forward. In terms of thinking about closing access to different types of people, my other commentators have spoken very eloquently about the fact that it's discriminatory to prevent, for example, single people, same-sex couples, couples who are living together, etc., from accessing surrogacy. And I have to say, I cannot see much grounds, substantiated grounds for doing that. So people who want to have a child in this way are usually the most committed parents you will find. They're going to all this trouble and effort and energy to have a child, and believe you me, they really want that child. So it's really important that they should be allowed to have children in the same way that other people are. So in terms of international, users of these services, there are some, and I believe that everyone should be able to access different types of care, whether at home or internationally. So again, I can't see a reason for closing borders. So lastly, just to summarise, I guess I'd say that it is the current absence of regulatory oversight and proper legal protections for surrogates that's actually the root cause of exploitation. So for all those reasons that I've just set out here, I think that the best outcome would be a revision of the bill that allows a small number of leading fertility clinics to offer compensated surrogacy services under the strict oversight and regulation of a single body that is akin to something like the Human Fertilisation and Embryology Authority in the UK, rather than a whole host of these, variety of different boards that have duplicative responsibilities and, where it's difficult to understand who would ultimately be responsible. So I think we can do this in a non-exploitative, well-regulated way that will make access to surrogacy open and available for everyone in a non-discriminatory way. Thank you.
Wonderful. Thank you so much, Bron. Thank you very much for your presentation. I believe now that Shivani can join us. Dr. Shivani, are you able to speak now? Are you able to unmute yourself? Okay. Okay, so I think we will probably, okay, please go ahead. Is that you, Dr. Shivani? Hi, we cannot hear you. Oh, okay. There seems to be some kind of problem, I think, in terms of unmuting yourself. I would. Oh, okay, but we still can't hear you, Dr. Shivani. I would suggest that you leave the meeting and come back in, maybe using a different browser, and maybe that will help. I'm not sure. But I think maybe in the meantime, we can go to Professor Ramanathan and we'll come back to Dr. Shivani. Go ahead, Professor Ramanathan.
Can I go on, Prabha?
Yes, please do. Thank you.
Okay. I don't have a presentation, and as it is very late in the evening for people in India, and perhaps later in the morning for colleagues elsewhere, my brief is to look at the ethical challenges, but it's very difficult to look at the ethical challenges independent of the language in which most of my other colleagues on the panel have talked about, that is the underlying thread of a discriminatory process which seems to discriminate against equals. So the ethical challenges with both these laws are very, very context specific, and therefore my comments may seem somewhat without universal applicability. Very often the law requires of us to be uniform before it, and any deviation is seen as potentially discriminatory. But in this context, these drafts are not emerging out of a socio-cultural or a political economic vacuum. It is in the growth of the privatization of infertility care and the potential or exploitative practices within such processes that have necessitated these laws. Without disputing this premise, it is still possible to critique them for their limited and inconsistent perspectives. There are also ethical challenges because they aim to retain gender inequalities within societies while aiming to protect vulnerable women from exploitative processes. So I'm going to look at these two drafts separately. The Assisted Reproductive Technology Bill seems to give systematically primacy to the rights of the commissioning parents of women and takes on the task of, protecting the surrogate mother and ignores entirely the rights of the egg donor, who may also be at risk. And in this context, the same state seems to be very paternalistic. And in doing so, it has always done that consistently, even with respect to the Preconception and Prenatal Diagnostic Techniques Act. So this is not new. However, if the state assumes the power to regulate parenthood by allowing for biological parenthood because technology allows for it, then should it not require commissioning parents all that it requires of adoptive parents other than only financial means? The laws have a greater requirement for parents by adoption. A home study report is needed, which looks at the prospective adoptive parents, including socioeconomic status, which leads to inequity, family background, description of home and atmosphere therein, and health status as per the format provided in some Schedule 7. The state seems to give adoptive parents far more scrutiny than commissioning parents. Is it because the regulation is for the private sector and not providing regulations for the public sector, given that 99.5% of the infertility clinics are in the private sector? It also penalizes almost all the stakeholders, assuming that ART centers and husbands of surrogates are not all there in the business to exploit women. In this context, the state seems to assume a very, very paternalistic role. It does so consistently because it has done so with respect to also the PCP and API. However, having identified abandonment of children as a potential possibility, I can't find a single statement of what one should do with abandoned children, other than penalizing all the people concerned. So it absolves surrogate mother of the responsibility or agency, but does not explicitly identify commissioning parents as the potential persons who may also abandon or cause abandonment, independent of each other. And that is another reason why I feel that the law privileges commissioning parents. Now, as for the Surrogacy Act defines what an abandoned child is, but I don't find any information on what action to take against commissioning parents or any action by others results in the abandonment of the child. And in addition, should such an unfortunate event ever occur, it does not explicitly state who should provide for that child thereof. It seems very, very morally inappropriate to force the child who has been abandoned upon the same parents, presumably who were willing to abandon the child at their own behest or of others. If the state does not take that responsibility, then who will do so? And that is not stated explicitly anywhere. What it does, the Act does not seem to address this, and this is another lacuna. For adoptive parents, there are so many regulations. The Surrogacy Act expressly prohibits commercial surrogacy, which is the very premise for drafting this law, I guess. The existing exploitative propensity as evidenced in the society. Given that the law is minimal ethics, maybe there is some justification. Maybe there has been, and there is a lot of scholarship to indicate all of that. But does that mean people are exploited by individuals or by the situation? The fact that Dr. Nayana Patel tells you now that in the times of non-earning, women are writing in to ask whether they could be surrogate parents is speaking to contexts that are exploitative, not individuals who exploit. It is in this context that the state has assumed a paternalistic view, protection of the surrogate mother from being held responsible for anything, including her agency, and therefore requires a demonstration of agency through an altruistic act. This is where the moral challenge comes. All efforts at donation, be it permanent such as organ donation or temporary such as provisioning of a uterus for a limited period, have to be necessarily altruistic under Indian law, and this stems from the need to prevent exploitation. But there is evidence before us to indicate that this altruism project is a failed one. It has systematically failed because in organ donation, we know that more women, wives, are altruistic towards husbands than any vice versa. There is evidence to indicate that the expectation of altruism is a failed project. To use that to premise another medical intervention is ethically challenging because it not only does not prevent exploitation, will probably make it go underground. And second challenge emerges from requiring couples to seek other women with altruistic tendencies while absolving such voluntary women of any agency and responsibility, and also forbidding any compensation even for time. It does provide for injury through insurance, but that is based on what harm may occur, not a just compensation for time. The prohibition of commercial surrogacy may not be unwarranted given the context in which it is being bought, and the risk of exploitation can equally be reduced if uniform compensation based on some scale is envisaged. Then regardless, not all women will volunteer, but those who do will be protected and from health adversity, which it already is, and reasonably compensated for time. But I don't think this is likely to happen given that the state does not recognize reproductive labor. Given that it cannot prohibit commercial surrogacy, and taking on a paternalistic view seems really very unfair, only with regard to surrogate women and not anyone else. And this is something which needs to be looked at very, very carefully. These are, apart from the other ethical challenges of being utterly discriminatory in a very systematic way against anyone who can actually provide, be it who needs children, wants children, anyone who wants and is able to do so, to provide for children should be enabled. Anyone who wants to volunteer should be enabled to volunteer. It cannot be premised on marriage, because to be able to donate eggs, for example, one needs eggs. One doesn't need to be married. And that is, again, to say that you need to be married is to bring it within a framework of gender inequality again, that to heterosexual marriage. And that is another axis of discrimination in addition to all that has already been pointed out. And with that, I will close for now and wait for more questions.
Thank you so much, Professor Ramanathan. I think it's what is really striking is although there are some points of divergence amongst the various speakers, I think almost everyone from every discipline seems to agree that the current proposals do not actually make sense and they're problematic for a whole host of reasons. So we are still waiting for Dr. Shivani to join us. And I think while we wait, maybe we can start, our audience has been very patient. So if any of you have questions, you have a function to raise your hand, I believe, or to type in your question. And I'm happy to hear from you all. Okay.
Hi, can I ask a question, please?
Yes, absolutely. Can you please introduce yourself?
Yeah, sure. So I'm Gargi. I work with the Center for Health Equity, Law and Policy, which is at TILS Pune. It's a relatively new outfit. We've just set up in April, and we're looking at using law to make health more accessible. So we've been looking at the ART bill. So one question I had was this. So now the bill has made the pre-implantation genetic diagnosis compulsory, right? And it only now allows infertile couples to use PGD, but can also then be used by fertile couples who otherwise have heritable genetic conditions. So I just wanted to hear your opinions and views on that, whether then should we ask for the expansion of eligibility criteria on infertility itself, because for couples who have genetic some conditions, they might want to use PGD and ARTs to make sure that they don't pass on such conditions to their children. And just wanted to hear your views on that.
Wonderful. Thank you, Gargi. I'll collect a few more questions if that's okay with the panelists.
Can I ask another question? Sorry, just have one more.
Yes.
So another thing is, I was just wondering, what are the systems in place for regulating which technologies themselves are used? So, like, I think Dr. Naina had mentioned uterus transplants. So, like, it's very experimental, but hospitals in, I think, Pune, Bangalore are offering it, maybe not on a, large scale commercial basis, but it's happening now. And maybe it will take off in a few years on a more, systematic basis. But I think there's still not enough evidence to say, the kind of risks it has for the woman who gets the transplant and for the donor. So, and this is just one example. So I just want to know if you feel that the Indian regulatory system is enough right now to regulate which technologies are being offered, and which, for health and safety reasons.
Thank you. I'll just take a quick question from Mr. Patil. If you want to introduce yourself.
Yes, are you able to hear me?
Yes, go ahead.
Okay. So it was excellent session. Dr. Naina, Professor Pravin, and Dr. Shivani, I'm eager to hear you. As you know, I have been working in this field in IVF for the last 27 years, and I also run a sperm bank. So the new ART bill, actually we have been discussing this on different platforms already, and at one point I was a part of the consulting committee for ART bank guidelines of ICMR, but then this bill it came from the sky actually, because nobody was consulted. Everything was especially about ART bank, means as Dr. Naina said, it was not consulted. The surrogacy bill, if applied in verbatim, the surrogacy business or surrogacy practices will be banned altogether. That is what means. Same way ART bill mentions about ART bank, the way they mention about altruistic sperm donation, no selling of sperm. One sperm donor can only donate to one commissioning couple. This is ridiculous. Means I don't know whether any technical or professional person was involved in this thing, because to get a single donor, we have to screen at least 10 donors to get one donor, and then that one donor, if this bill wants us to use it only for one commissioning couple, just imagine how expensive, how unviable the whole sperm donation. So I think their intention is to just close down ART bank and surrogacy services and all these things. That is my this thing, and I think Dr. Naina, with your network and as the earlier participant said, your Gujarati connection, I think this has to be corrected. And actually, this is very ridiculous. Means where are we going actually? Because everything was going just for the sake of certain bias that doctors are doing this and doctors are earning money doing surrogacy and all this. This is an unjustified bias actually. Means we have to really have our own big voice to modify all these things, because this is going nowhere. That's my comment.
Thank you, Mr. Patil. So I think we have Dr. Shivani has rejoined us, and I really hope we can hear her this time. Dr. Shivani? We are not able to hear you. Are you there? No. Okay. That's quite unfortunate. But we will keep trying. I saw another hand go up, but maybe we can go. Was it Riyansh? Did you have a question? Okay, no. Yes.
Good evening, Professor Kotiswaran. This is Skylab. Actually, I'm using my son's computer and his app, so that's the reason his name is appearing. First of all, a very big congratulations to the entire panelists. The knowledge and the experience that I could come to learn was really tremendous, and specifically to Professor Prabha Kotiswaran and Professor Mala Ramachandran's speech was really enlightening. And with that, I have just a kind of observation and an impression to share with you. It's about like it looks like as if the bills are going to put the issue of reproductive rights of women under peril totally, because the question of choice of having a control over one's body is something which is not going to be given enough emphasis on. That's what is, and you could please share your views on that. Thank you.
Okay, thank you. Thank you, Skylab. So is Dr. Shivani able to speak now? Can we hear you, please? No.
Prabha, can she browse her slides? We can go through that, just what message she wants to get. Because she has a presentation ready. She may not speak. Just...
Sure. Shivani, would you like to, share your screen and, start at the beginning of the presentation? And we can at least get a glimpse of what you're thinking. Maybe, I think in the meantime, would anyone like to address the 3 questions? I suppose it's really, there are other technical questions for the doctors. But who would like to talk about it?
The PGD question. The PGD Gargi had asked, it's already been done. Now we call it PGTM, pre-implantation genetic testing of monogenic disease. So that family or the sibling, and when we know that a husband or the wife is a carrier or both are carrier and we do not want to pass it on to the next generation, even a fertile couple can do it for an existing disease, and that's already being done in India. And doing PGTA or PGS is not compulsory, that all couple will have to undergo that. That is not there in the bill. But any couple where the female is of the advanced age or they had repeated miscarriages or repeated IVF failures, we can screen the embryo to find out whether it's chromosomally normal or abnormal and then implant into the uterus. That is one thing. The second, uterus transplant is very, very primitive right now. Though it is practiced, India claims of only one live birth, one abortion, and the female has to undergo, the one who is donating uterus has to undergo a very elaborate surgery where it is implanted, the female is under immunosuppressants, IVF and embryos are created before. After putting in the embryo, while she is pregnant, she is on immunosuppressants that can give rise to growth retardation in the baby, preterm deliveries and complications. And once she delivers, which is always by a C-section, then again a surgery to remove her uterus so that she's not on immunosuppressant lifelong. So we are jeopardizing the health of 2 females at the same time with extensive surgeries. And even after that, we don't know whether the uterus is going to remain, or even before she gets pregnant, it can get rejected and necrotic. And even during pregnancy, she may have to abort and remove the uterus. So the complications are a lot more worldwide. Regarding the abandonment of the baby, which I heard Mala say, in the original guidelines, there was a draft where they said that if a baby is abandoned by a couple, it can be offered to the adoption agency in India. Really looking at the abandonment of the surrogate babies, I would challenge that how many cases have you heard in India? I don't even remember one case being highlighted. Baby Manji was not such a case. She was not an abandoned child. The parents were there to take the child. It was just hyped up by the media. So in reality check, if you see, there are hardly any cases of abandoned child. But in the original guidelines, it was mentioned that it has to be offered to the adoption center, the adoption agency in India.
Dr. Patel, while we have you there, could you also reflect a little bit? I think many people have tried to call upon your regional connections to change policy at the central level. What do you think the prospects are for that?
Well, we have done our best. We have been to the National Commission of Women in India, where we have said that it's helping the couples, it's helping the surrogate mothers also. And we were told that don't worry about the surrogates, we are there to give them the employment, and we don't need. Then we talked about the OCIs, that people of Indian origin living abroad, they would want an egg donor from India, they want a surrogate in India. They said as they are living abroad, they are enjoying the life abroad and they are earning abroad, they should spend also abroad. So these were the answers we got. But by now, as Mr. Samir said, that this government is quite open, they are listening. So slowly and gradually they are understanding, and that's the reason I think they've opened up the export and import, because it's our brothers and sisters also suffering abroad. And even foreigners, I would really say that foreigners are they're lovely as when they come to collect the surrogate babies, when they do surrogacy, they really, really respect the surrogate mothers. I don't see an iota of exploitation when the foreigners come to India. It's not that they are rich abroad and they are coming here. Some of the foreigners are not even rich. They've just managed the money to come to India and do surrogacy. So I don't see that they come to India to exploit. And they really care for their surrogate mothers, just like our Indian parents do. So there is no point. Indian parents also respect the surrogate mothers, so do the foreigners.
Thank you very much. I think the broader question about what exactly is the government trying to do, when the surrogacy bill came, there were some observers who said, well, it's being shut down so that the ART sector can profit from IVF. And now it looks as though the ART bill is also complicating that considerably. So I'm just wondering whether any of you have thoughts on what you really think the state's intention is here. Is there actually a well worked out plan, or is it simply that it's being passed through bureaucrats without any understanding of the medical nuances of either the medicine and how these clinics actually operate? Any of you can reflect on that.
Could I make a comment on that, Prabha?
Yes.
I'm really struck by the fact that it seems to me, actually, that where the surrogacy regulation bill came from, and I say this from a distance, but working off what Naina Patel has just said, of course, in any kinds of agreements like this and any kinds of processes like this, there is always an opportunity for exploitation to happen. Of course, that is possible. But in all the time that I was researching this in India, I did not see actually any substantive evidence of surrogates feeling very exploited or being very exploited. In fact, in many of the clinics that I went into, they only required, one surrogate, and they had 10 or 15 women who were seeking to be surrogates. And I saw them crying in the lobby when they were told that they were not going to be surrogates. So, these women are not unintelligent. They're not stupid. They're perfectly capable of assessing this situation. And for many of them, they felt it was something that they could do and were able to do. So I actually think the impetus for the surrogacy regulation bill does not actually come mostly from their experience, but it comes from the fact that in social media and in the international press, India started to get this, bad press for being some kind of surrogacy hub. And by the way, a few tiny cases like baby Manji and so on were thrown up, baby Gammy, were thrown up as examples of when surrogacy goes wrong. But actually they are minute. They are a minute fraction of overall surrogacies, most of which end very well for both the surrogate and for the intending parents. But India became very sensitive to being criticised internationally for being a hub of surrogacy, and that surrogacy was a bad practice and renting your womb was a bad practice, and all this kind of florid rhetoric around surrogacy being bad. And so I understand that India thought, oh God, we're being really badly criticised internationally. We need to shut this down and we need to do something about it and so on. I think that's what they have been responding to, really, actually. But I don't think that there is evidence to substantiate that is really, that there is really a lot of bad exploitative practice going on in surrogacy. I don't actually believe that. I think it's more a number of sensational, big media stories that gave the practice a bad name, which is not really evidenced in my view. But we need to give Shivani a go because that poor woman has been trying to get on for half an hour here.
Thank you so much, and I'm really sorry. I don't know what has gone wrong where, but can anybody hear me right now?
Yes, we can. Good to see you.
Oh, that is, my God, thank God for that. That is really a big success. And I'm just going to share my screen.
Go ahead.
Share. Okay. And so can you see this presentation right now?
Yes.
So I just wanted to say that thank you so much for the opportunity. I was invited by the Rajya Sabha Parliamentary Committee, and this was some of the data we had collated at that time to present, because everybody says there are a lot of myths and misconceptions. So I just wanted to give a little brief information and data. Right now, as we stand today, where do we stand in India? Legal status of surrogacy under PCPNDT. So see this notification of 2014, number 2. This says that all the surrogacy clinics and in vitro clinics are right now under this PCPNDT Act. And this presentation, I'm skipping these slides because people have already mentioned about this before me. But I wanted to mention one point specifically because this was picked up by the members of parliament who were there in the committee. That in India, we have different sects. For example, we have a Niyogi community here in North India, where property can be inherited by the widow if she is bearing a child for close relative. So this is a big source of custody disputes, property disputes, and this is one of the huge reasons why close relatives is very, very impractical, especially for the area of North India. Other things have already been mentioned, and I wanted to present some statistics from all over the country. So I will thank Dr. Naina Patel and Dr. Samit Shekhar from Hyderabad, Surrogacy India from Mumbai, and Anna Med Services here, International Fertility Center, Dr. Bhavishi, because everybody has contributed to this. So we were told that there are Dalit women who are being taken as surrogate mothers. There's exploitation of Dalits. So we actually went back and checked what is the caste of the surrogate mothers, women who are doing surrogacy. We found that 13% of them are belonging to the Dalit community. So there is no over-representation of Dalit women in surrogacy. I don't know if you have seen this RTI application. This was sent to the ICMR in 2015. Question number 2, how many complaints by surrogate about exploitation by doctors has been received by ICMR? ICMR has not received any such complaints. Then people say, one of the speakers was also saying that people think that the babies who are born by surrogacy are not healthy, they are defective. This data comes from Mumbai. Look at the average weight of the babies which are born by surrogacy. It is almost 3 kilos. Even look at the average weight of the babies born in twins, as twins. The average weight is all about 2 kilos. The average, people say they are delivering babies preterm, whatever. So take a look at the majority of the babies are delivered after 34 weeks, which is a near-term pregnancy. And this is a force of nature. You are never going to be able to deliver 100% of the babies at full term. There will always be some amount of preterm delivery. But this is well within the norm. This is not anything higher than a non-surrogacy population. This is again gestational. And this is a country where this is not relevant now because now we are not allowing international surrogacy, but surrogacy versus the normal population, if you see death, hysterectomy, pre-eclampsia, this was data which has been collated from all over India. So it is not, these are very highly selected population of women with very low risk factors which have been taken. Compensation, in case you are wondering what are the surrogate mothers doing with the compensation, majority of them are putting it towards some property, some kind of house, or putting some fixed deposit, or they are running their vehicular expenses or some other expenses. Reason for surrogacy in India, now this is 1,000 patients data. Why women are doing surrogacy? So the commonest reason in India where people are doing surrogacy is multiple failed IVF cycles, multiple miscarriages, and endometriosis. These are all the factors which have to be included in the bill as a cause for surrogacy. Because if you just say that women who have absolute absence of uterus, that is only 8% of the women who are doing surrogacy as of today. Surrogate mothers from Delhi, from my clinic, they've gone to the ICMR here, they've gone to NCW, and these are few questions that was done in a survey asked by them, and these are, all the clinics that have been involved in the survey. Let me show you. Why did you decide to be a surrogate mother? It was open-ended question. So you can imagine 170 women, we will get a whole range of answers. But the most common answer that we got was बच्चे के भविष्य के लिए पैसे की जरूरत थी, सोच कर फैसला लिया है, अच्छा लगा. These are the kind of things that people have written. What would happen if you change your mind about being a surrogate mother? So the most common answer that we got was मानसिक रूप से तैयार थी, मुझे सब पता था, मुझे क्लिनिक पे भरोसा है, नहीं बदलूंगी. Was it your decision, or did somebody in the family push you to be a surrogate mother? So my family and me, this was the most common answer, that it was a joint decision. How did you hear about surrogacy? Who told you? So the most popular answer we got was a family member or a neighbor or a sister or a friend. So it is word of mouth that they are hearing. Now, what does your family think that you are going to be a surrogate mother? Most common answers we got was acha, khush, theek. These were the kind of answers we got. What does the family think? Again, the same thing. Acha, khush, theek. What concerns? Now, of course, we are going to have a lot of answers here, but the most common answers that we have here was पहले कुछ डर था, पर बाद में समझ आया तो डर नहीं था. दूसरी सरोगेट मदर को देख के समझ आया, कोई चिंता, कोई सवाल नहीं था. So these were the, what is the plan with the money? Now this is again the chart that I have been. What information you want about the parents whose babies you are carrying? So the answers that we got was, most of them were saying कि जानकारी नहीं चाहिए, बच्चे के भविष्य के लिए समझदार रहे, अच्छी परवरिश करे. Would you like to meet the parents? What kind of contact would you like? Most of the women, 58% said nahi milna hai, and the others 42% said haan milna hai. Now, what will you tell another woman who's planning to be a surrogate? So the most common answer was sab अच्छा है, मैं अच्छा विचार ही बोलूंगी, कुछ गलत नहीं है. So these are, and the other things about, whether I think this was mainly what I wanted to say, give some of the data and presentation just to add. Thank you. Thank you so much for the opportunity.
Wonderful. Thank you so much for, we are so glad that you could finally make it, and it was great to hear you. So yeah, I just...
Thank you.
Yes, thanks a lot. So I just want to invite anyone else. Are there other questions that, those of you who are attending the panel have for any of the panelists?
Can I ask a question?
Yes.
I'm Ruby Bhardwaj from Delhi. In today's paper, there was an article about savior siblings. Now, so the sibling was created through selection of embryos for the sake of saving a thalassaemic sibling. So I want I want somebody to help me about what do you think is the ethical, what are the ethics involved in it? Do you think that, because, this would then lead to designer babies, because, they had 9 embryos, out of which they took 1, which was the right one, which could give the bone marrow donation. So what do you think on that? Somebody who could help me with this.
Great. Any of the doctors or the ethicists?
Whoever wants to take it.
Yeah, as far as I know, savior siblings are nothing new. They have been going on for many years. If you see international literature in the US and the France, in France, in Europe, all over the world, many savior siblings and babies have already been conceived. This is something new in India. It has just come now in India. This concept, maybe you are reading for the first time, but all over the world, this is being practiced already.
The ethical issue, I think, over here is that do we have the right over the baby which is unborn, and do we need to subject that baby to donate the bone marrow to the sibling? But I would say that yes, ethically, you may be that your concerns are correct. But when you look at the couple or the baby who is suffering from thalassemia major and needs 80 transfusions like in 2 years' time, and if the same baby has a sibling, like if even today if you ask, you would be willing to do anything for your sibling. So here, rather than subject the older brother or a sister to a hard life, if a younger brother or sister can help that sibling give a better life, I don't think any ethicist should have a concern.
Prabha, can I address it?
Please do.
The discourse on this in this context for the person asking the question has been two-edged. That the agency of the child that is created to protect another child is challenged because it's voluntariness. The person doesn't have a choice. But the other side is, from a human rights or a human being, we exist for ourselves. You don't get created socially we are made to believe that we exist for our husbands, we exist for our children, we exist for everyone else. But we exist for ourselves first, primarily. The reason why we get created is because of a procreative process in any which way, artificial or natural. However, no one is created because of the need for another person. And in this context, we don't have enough evidence, very limited evidence on how the people who were created merely for the existence of another person felt. Very limited evidence, but that limited evidence indicates that people did not mind. But what they minded was that, did people really not care about them, but only about someone else more? And that is your, what shall I say, evidentiary basis for the moral challenge. But the moral challenge is, each one of us has a right to be for ourselves. And therefore comes that asking another being to be born only for the existence of another person can be problematic, because the second person who is born for the sake of the first person, who has to continue to live a better life, nobody will say no to that. But if they feel morally challenged that I will not exist but for that need, then they feel belittled somewhat.
Okay, that's great. Thank you. Thank you very much for those responses. Are there any other questions for the, yeah, Sophie, please go ahead.
Yeah. Thank you, Prabha, for organizing this very wonderful educative experience on surrogacy debate, the recent surrogacy debate. The question is, while we are discussing from social justice point of view, while we discuss fundamental rights challenge to right to livelihood of surrogate mothers, the other question that comes to question is the question of accessibility and affordability to the technology. So I'm just curious to know whether there is anything in the regulation specifically looking at accessibility question towards the technology for socially marginalized or financially backward parents or the clients. And is there any pricing regulation or prohibition of differential pricing that exists non-statutorily in the business otherwise? Thank you.
Excellent, Sophie. I'll just give you the quick legal answer, which is that the ICMR guidelines in 2005 actually spoke about, reducing the prices of, say, for example, ovarian stimulation hormones, which were, I suppose, being produced by multinationals. So there was a very strong redistributive impulse in the initial guidelines, it's not something that has actually been followed through in the subsequent versions of the draft. But I'm sure our doctors would be able to reflect on how how they're able to manage their patient profile, and if how they're assisting those who don't have access to expensive ART treatment.
Recently, government has started opening up the IVF centers as some of the government hospitals. So that will definitely help this section of people. There are pharmaceutical companies who definitely give free drugs to patients who would need it, though it is a very small limited number. And there are centers, like most of the centers, playing a little bit of Robin Hood, that an affording patient can pay more, but when a needy patient comes in, we can compensate the injection cost to a literally very, very low level and help them go through their IVF cycle. Shivani, what do you say?
Yes, I agree, ma'am. It is really unfortunate that all over the world insurance is excluding fertility treatment. So there is a huge push by our association to request for insurance firms to include fertility treatment. And in Delhi government hospital also you have to pay 60,000 rupees to do an IVF. So it is not free in Delhi. Government hospitals have started offering it, but it is not covered in insurance and it is not given free in government hospital also. So cost is a very big limiting factor. It's a very critical question, very important question, but there are no good answers. Insurance would be one, and otherwise. Because the main crux is that in our country it is considered that population is a problem and assisted reproduction is not a priority. So the basic thinking and the mindset has to change. Only then something can change.
Prabha, can I add a bit to this?
Please do.
I can't remember who asked this question, but for sure, government is coming in with regulations and it is not prescribing guidance on how to act. Tells you a lot about the policy making and in what political economic context it is making a policy. That existing ART centers and surrogacy centers are in the private sector. There are very few in the public sector. Consequence is there is no option but regulation. And that is why you're having regulation now. But having said that, equity is not a guiding principle. If equity is not a guiding principle, it is not likely to be part of the guidance at all. It's regulating, an attempt at regulating the private sector. Therefore, equity is not an underlying principle. Gender equality is not. It is merely, how shall we say, it could be, as someone else has pointed out, the worldview of how the world looks at India. But the other side could be what international researchers have pointed out to transnational imageries of transnational, surrogacy, etc., which is fueling this. But whatever be the guiding principle, equity or creating equity is not one of the guiding principles.
Wonderful. Thank you so much. Are there any other questions? Or I realize that we are almost out of time. So I wondered if the panelists had any comments on each other's presentations or if they had any concluding thoughts on where we go next as well. Any questions for each other?
I thought the presentations were great, really comprehensive, really interesting, raised many issues. I thought there were a lot of, points that were similar across the presentations, which is good because it points to the fact that we are pretty clear about the areas that really require a further revision and consideration. In terms of where it goes next, I guess the question is whether there's any room for proper last revision of this bill, or whether it will just go through whether we like it or not, or whether there are problems or not. So, we've pointed out many of the problems with this bill. There are quite a few. Whether it might be worth, after this meeting, agreeing what we think the worst of the problems are, and trying to concentrate our attention on, some revision of particular clauses. So, for example, I think almost everyone in this meeting is agreed that restricting surrogacy to women who are close relatives of the intending parents is a big problem. And it's too prescriptive, it reduces access. That's a problem. Even if that were revised in the bill, that would help. That's a major change in the bill, and whether or not that would be acceptable, I don't know. But just getting rid of that clause would be a great success in my view, but other people might have other views.
I saw one hand go up. I'm not sure, but it's been pulled down. Vasudha, did you have a question for the panelists?
Oh, sorry, Prabha, I did it by mistake. I apologize.
Okay. No problem. Okay, so let us continue then, gazing at the crystal ball, I suppose. Do any of the other panelists want to reflect on what the way forward might be? Clearly, in relation to the ART bill, there's scope for discussion, but maybe the window on the surrogacy bill is, closing down. But I'd love to hear what you think.
I just have a very brief intervention on this, which is that, as Professor Koteswaran rightly pointed out, that there is now the opportunity of getting heard in front of the Parliamentary Standing Committee, which will examine the ART bill, and possibly one way of also having some leeway of some amount of changes on the surrogacy regulation bill can be to then push for consonance in terms of the way rules for both these acts are framed. So in front of the committee, if depositions can sort of emphasize that even if the bills are not working really in the tandem, at least in the formation of the rules, there can be like a more unified approach, because I think that there cannot be enough emphasis on the fact that these two bills have to be seen in complementary ways.
Wonderful, thank you. How about anyone else? Any of the other panelists?
Yeah, I remember,
Yeah.
Prabha?
Yes, go ahead.
One alternative is to also get as much of the criticisms in a public domain through publications which can be faster, for the simple reason that we will have some document to show to the parliamentarians who are in the standing committee. Now, parliamentarians want to be a little bit wary when their own constituents point out things. So we could email our own elected representatives to do stuff, which I don't know if others could do it, but we can do it in Kerala.
Okay, that's definitely a way forward. Yeah.
I feel it has to be something radically different approach. Like these webinars can help educate people. We have to look beyond the parliamentary committee. See, that particular committee has a mindset. A mindset of its own for them to accept that their thought process itself is wrong. The drafting of the bill is wrong. The definitions are wrong. It will see for you guys, the doctors and all. It's the end of an industry. For people, for parents who want kids, it's end of a dream. So probably the doctors will find alternate ways of uh, other livelihood means, and you're diversifying into other fields. What will happen to the parents? Between Dr. Nena Patel, Dr. Shivani, Dr. Kaveri Banerjee, and that Mr. Pai, you guys have also helped some very very important people in the process. In the sense one of these film stars, somebody can be made a face of the entire point, you know, and reached out to the highest quarters. You know, you'll have to have the backing of people who think in a different manner in the ruling government itself. You know, the opposition in India doesn't exist anymore, so they can't help us there. Uh, for common folk, even discussing surrogacy, kids outside wedding is still very at a nascent stage in India. You know, in terms of it's the rich or who are reaching out for surrogacy and stuff like that. So I feel, you know, we have to identify some big face who will become the face of this entire talk to the highest quarters.
Yeah,
I don't know. I don't know where all these big stars, the Shahrukhs and the what do you
yeah,
call that, Jitendra's daughter and son went to.
yeah.
You know, so one of these guys
Mhm.
can be spoken to. Hardik Pandya can be spoken to. The you know, अभी आपने मैम उसका जो बेबी पैदा किया, he can reach out to a Shahrukh Khan very easily, yeah.
Yeah.
You,
So
you know,
what?
so
Say
Yeah.
was that the sufferers are going to be the infertile couple. And people
yes.
can throw a lot of money, like the Khans, etc. They can
Mm.
go abroad, get whatever egg donation, surrogacy, spend 1 crore, 2 crore. But what about that middle class India who can barely afford an IVF in India, a donor egg in India, and so on? They are the sufferers. As he rightly said, they are the biggest sufferers, then comes the surrogates and the egg donors, and the last is the doctors who will try to channelize their activity in other area and get them. So the government should think about these infertile couples, the beautiful children who are left out and will not be born, and the surrogate mothers before they make any bill as an act.
Okay. Wonderful. Great. So, Dr. Shivani, do you want to also share your thoughts on this?
Yes, thank you. I agree with the previous speakers, and I really wanted to emphasize that I have been to the Supreme Court also, because I don't know that if you are aware, the Jan Bala's case is still going on, and whatever representations we have done have already been added to the Jan Bala's case. So I have spoken on the opposite side. We had the respected Solicitor General of India and some of the other advocates. And what I've spoken to them, they tell us if I ever needed surrogacy, I would never do it. I would just adopt. So as the the person, your parent who is here has said that they don't understand, it is not priority for them. So that understanding has not come. Unless that doesn't come, I'm not sure how far we can go.
Okay. Thank you. Thank you very much. And I think
Can
I'll
I
have.
just say, Prabha, can I just say quickly
Yes.
something in response to that? People often say that it's not a problem, just adopt a child, okay? And therefore we don't need surrogacy. And what I always say in response to that is, okay, that might be true, but in which case, if that is your argument, then you should stop all ART around the world for everyone, because you can't have one regulation for some people and other regulations for other people. So if you're saying that, then you're saying anyone who has infertility of any kind, whether your eggs don't work or your sperm doesn't work, you should just go and adopt a child. That's that argument. And it does not work, because then every fertility clinic across the world would have to shut down and just people go and adopt children. Well, that is not going to happen, because people want to have children who are genetically related to them. Whether, some people are happy to adopt, and some people want to have children who are genetically related to them. And if you want to have children who are genetically related to you, then you have to have, and you're infertile, then you have to have assisted reproduction. And so it doesn't make any difference whether what you're having is infertility treatment like IVF or whether you're having surrogacy. You're the same people. You are infertile and you want to have a genetically related child. And so you should be allowed, if we're saying people who are infertile should be allowed to have a genetically related child, then that should go for everyone who's infertile, not just people who have some kinds of infertility and not other kinds of infertility.
Wonderful. So
Thank you, Professor Parry. Just one point, because this is a very commonly used answer that it shouldn't. What they counteract with is that they say that when we are doing IVF, I'm not using somebody else's body. We are using our own body. So that is the difference between IVF and surrogacy. That is their counter argument.
I'll give you the argument, the counter argument, which is that, you know, if you're using a surrogate, you're using somebody else's body. If you're using somebody else's sperm, you're using somebody else's body. If you're using somebody else's eggs, you're using somebody else's body. It's all using a third party to enable you to have a child. And there is no difference, in my view. So you're either using somebody else's help to help you have a child, or you're not. So, you know, if you are, I don't see if it makes much difference if you're using their sperm, their egg, or their uterus. You're still using a third person.
And there are no children for adoption, hardly any. People are in the queue for 3 years, 4 years, but still cannot adopt a child.
Yeah. So I think Dilip and Sneha, very quickly, if you want to make your interventions, and then we will close because we are already over time. Very quick.
Yeah, it was a very quick point, which was actually the converse of what Professor Parry was saying, which is also true, which is the fact that adoption and having children through adoption or other modes of parentage is a social problem, and the burden of solving that social problem cannot disproportionately lie on people who are suffering from infertility. It is a larger question which also needs discussion of a multi-pronged kind, and one part of it definitely is the institutional hurdles to adoption, and the other is that we really need to talk about building alternate families, and adoption is a mode for it, but it is not an option just for people who are infertile. Yeah.
Wonderful, thank you. And Mr. Patil?
Yeah, I just have a suggestion. As Mr. Earlier speaker said, that rope in some actor or some public figure in this campaign. So all these TRP hungry channels can't be, because it's a public interest discussion actually. So why can't we approach, or the media houses or all these electronic media, can they not have discussion on this very important, which is concerning lives actually, creating lives, and the government arbitrary regulations. So why can't we have discussion on media? Dr. Naina, again, can you use your good offices with this media houses?
Yeah, I think I'll let her have the final word, and then we will close the session. Thank you. Thank you, Dr. Patel. Do you want to quickly respond to that?
I would just say that everybody should play a part in this. It should be a common awareness, social awareness, trying to educate your MPs and MLAs in your area, the parliamentarians, and as Mr. Samir said, go to the top level. And that is what we are trying to give a proper presentation and trying to see that if this can be done. And I'm sure this government is not saying a big no. They are gradually looking into it deeper, and hopefully it will be a balanced way.
Wonderful. Okay, thank you all very, very, very much for taking time from your precious, very busy schedule. I'm very, very grateful, and this conversation will continue, and you have our addresses, and I hope all of us will turn out in great strength in the public consultations around the ART bill. And thank you all very much, and stay safe. And I will share a copy of the recording when it's available. Thank you all very much. Thanks.
Thank you.
Thank you very much, Prabha. Thank you.
Thank you.
Thanks.
Thank you, everybody.
Thank you.